Episode 84. First game, first shift, first shot, first goal for Mary Lemieux on October 11, 1984. 1984 was also the title of George Orwell's last novel, and the real yield on the US 10-year Treasury in 1984 was 10%. This sparked a bond bull market, with the Treasury returning 13% in 1984, 25% in 1985, and 24% in 1986. Beyond MD, episode 84, here we go! Hey everyone, welcome back to the show. Today's topic is a heavy topic, but a very important one. And I would deeply appreciate it if you can share this episode with other people in our physician community. Today, we're going to be diving into what happens if there is a malpractice claim against us. What happens if we're sued and if there is a lawsuit? What does this entire process, with its emotions, the time commitment, and the finances, what does it look like from start to finish? I think most of us have probably only thought about this on the surface, but the truth is, everybody listening today probably knows at least one person who had to endure this process. Guys, remember, our ability to work is our greatest asset. And when situations like this arise, and they certainly can arise, it's really important for us to know how to navigate them. That's why I'm really excited to host the CMPA on the podcast today. The CMPA is the Canadian Medical Protective Association. It's an organization that essentially all of us are familiar with, but most of us probably only understand it at a more surface level. So today I'm delighted to host Dr. Todd Watkins. Dr. Watkins was a family doctor, but for the last 12 years he has been a core part of the CMPA's leadership and currently serves as the organization's associate CEO. So today, Dr. Watkins will take us from start to finish what happens when a malpractice claim is made against us. Please enjoy this conversation. Okay, Todd, welcome to Beyond MD. And I really want to thank you for making the time to talk with us today, because I think the topic we're going to discuss today, the CMPA and what it does, is misunderstood, or at least not deeply understood by a lot of people in our community. So again, thank you for being here. It's great to have you.
Absolutely my pleasure. Thank you.
So Todd, why don't you tell us a bit about your professional journey to this stage and your role at the CMPA and how long you've been here?
I'm a family physician by training. I trained at Western and Queen's University. I came to the CMPA over 12 years ago. And when I came here, I came into the role as Director of Physician Services, which oversees all of our medical legal activities and the physician assistants in the organization. I most recently, over the last 4 years, have assumed the role of Associate CEO, and I'm more responsible now for corporate activities such as governance and stakeholder engagement and advocacy.
Oh, amazing. And are you still practicing family medicine right now as well?
I'm not any longer. Since I came to the CMPA, I've not been able to practice clinically.
And Todd, can you speak to the mission of the CMPA and what its goal is in supporting members in Canada?
You bet. So the CMPA is a member-based mutual defense organization, and we're unique, and I'll get into the details of why we're unique in a second. But simply put, our goal, our mandate is to protect the professional integrity of physicians and promote safe medical care in Canada.
That term there that you use, like a mutual defense organization, can you maybe just elaborate a bit on that, just so I can fully understand what that means?
Sure. So as a mutual, we are owned by all of the physicians in Canada, and all of the physicians in Canada share the risk and liability associated with the care that we deliver across the country. And our funding model is founded on that mutual defense approach. We were founded in 1901, so we're coming up on our 125th anniversary, and then we were incorporated as a special act of Parliament in 1913, which makes us quite unique as well.
Amazing. I love all types of history, so I do appreciate that. So Todd, can you tell us a bit more about how the CMPA helps its members?
So the CMPA provides protection for physicians, and we promote safe medical care in Canada. But let me tell you a little bit about how we actually do that and the range of services that we offer, which does make us unique. So we are the largest medical association in the country, which comes as a surprise to many. So we're creeping up on 115,000 members across the country, which is very large. Our range of activity and assistance goes from providing medical malpractice protection and advice on civil legal claims, lawsuits, But we also provide assistance in college matters, in hospital matters, in privacy matters, in billing matters. And they account for about 8,000 of our files every year. So every year we open about 8,000 medical legal files. Not all lawsuits, but mostly college and hospital matters and complaints, those kinds of things. We open up about 800 lawsuits every year. In addition to that, we provide advice to physicians. So we actually speak to over 20,000 physicians a year, just providing advice for their practice, trying to mitigate risk, provide health and well-being support related to risk, and really be a partner in practice. We know that it's really tough out there. It's probably never been tougher to be a physician in the country. And so we really are a resource for physicians on an ongoing basis.
I really appreciate that. And I will say that that first number that you mentioned, 8,000, I guess I was relieved to hear that, though that wasn't the number of lawsuits, but that was just kind of the number of cases overall that were opened up. Now, on that point of just supporting physicians in general, like let's say somebody is dealing with a case at work that they might be a little bit worried about. Is it reasonable in that case for us to just pick up the phone and call the CMPA just for advice if we're worried about anything? Is that something that's reasonable to do?
Absolutely, anytime, and we encourage it. So we have over 40 physician advisors who are employed by the organization working full-time to provide that support. And that's one of the elements that makes us unique, in that we have peer-to-peer support at the other end of the phone to guide physicians. And when we survey physicians with respect to the impact of that first conversation in reducing stress, it's significant. So we pride ourselves on the ability to provide physicians with the information that they don't have in order to both enhance their safety, reduce and mitigate risk in their practice, and really help them through the course of their day.
So let's now get to that smaller number. I think you mentioned around, let's say, 800 lawsuits a year. But let's say that a physician does learn one day that there is a case being made against them. How would they typically find out about this? I imagine it could be a very stressful moment, but how would you find out about it?
Sure. So that can come in a variety of different ways. So people will have heard the term, I've been served. And that's not always as scary as you see in the movies, where someone shows up on your doorstep unannounced and slips a letter under your door and runs away. That's not what happens. Typically, somebody does show up to your office or your house with a document. They typically contact you beforehand to tell you that they have a document for you. You may also receive it if you're a hospital-based physician, in your inbox at the hospital. And the process is called being served. And it can be very stressful. No one wants to receive that letter, whether it's a lawsuit or a letter from the college that calls into question the care that you provided. The other way that physicians can hear about a lawsuit is through word of mouth.
Okay.
So typically, when you're served with a statement of claim. And the statement of claim, I can speak to that with respect to its components. But in there, one of the things that it lists are the other people that have been named in the lawsuit. So you can imagine that if you're in the hospital and one of your colleagues has been served and sees your name there, they might come up to you to ask you about that.
Okay.
Now, typically, we advise that you don't speak with your colleagues about the case, but certainly word of mouth is a way that people do find out about a statement of claim.
Are there any limits to what type of information can be on that statement of claim, or can it really have anything that the other side so desires? I'm just curious, what can we, because I imagine when you get something like that, quite nerve-wracking, quite emotional, but what else could it contain?
Yeah. So it typically has four components to it. The first are the people that have been named in the action, as well as the plaintiffs. So in that instance, you'll know who's making a complaint of you, and the other people that are being named in the statement of claim. It will outline the basic facts and the allegations contained in there, and it will outline the damages sought. So the amount the quantity of the remedy sought will be included in the statement of claim as well.
Okay.
Now, how it's served to you and when it's served to you is interesting because they have up to a year to serve you. So when the statement of claim is launched by the plaintiff,
Mm-hmm.
your colleague may receive it months earlier than you do, for example, for a variety of different reasons. So once the plaintiff has launched the statement of claim, they do have up to a year to actually serve all of the players in the statement of claim.
Oh, I see. Okay.
Yeah.
And now that we're speaking about timelines, how old can a case be for it to be a valid malpractice case, for it to be kind of valid on a statement of claim? I imagine there's a certain period of time that things can go back.
Right. So that's typically called the limitation period
Mm-hmm.
in a lawsuit. And it's typically 2 years in Canada, but that's with a lot of qualifications around that 2 years.
Okay.
So it really does depend on when you start the clock ticking around those 2 years. And that is defined by the time when the plaintiff knew or ought to have known there was an issue. So you can imagine an instance where care is delivered and it's not till years later that the patient questions a side effect or an outcome of something that they had, that they're now realizing it may be related to the care that they were given. So the limitation period, while it's 2 years, you have to define when the clock starts to tick. Now, it's even a little more complicated when it comes to compromised children. And so when you call into the CMPA, we typically tell you to keep your files and records for at least 10 years after the time of care. But for children, it's at least 10 years after the age of 18, because while the parents may not decide to launch a lawsuit, the child has the ability to launch a lawsuit. And so you want to make sure that you've retained your records. And the courts have been very lenient with respect to waiving limitation periods in certain cases.
Are there any other scenarios that may not be subject to that 2-year limitation period that we should be aware about?
I think anytime there's an allegation of negligence, as I said, the courts are quite lenient around that. And not only that, it is very difficult to get a case dismissed on the basis of of limitation period. So I wouldn't use that as a defense.
Now, in my reading, I did come across a few terms. One was knowledge of events. The other one was cause of action. And I just want to make sure I understand these terms. Are you able to elaborate on this a bit?
Sure. I might answer it in a slightly different way, perhaps, and you tell me if I'm hitting the mark. So there may be a time when, let's use a scenario where you've delivered care and you've disclosed an adverse event to the patient. So that might trigger for you a knowledge that there is a risk. And as you had asked me earlier, we appreciate when physicians call in and ask for advice related to that, related to things like the medical record, right? For example, and we strongly encourage people not to make any adjustments to the medical record,
right?
Or if they need to, based on the facts, we really encourage them to call us first, and so that we can provide guidance on how to do that properly. So those are the knowledge of events. As an example, the cause of action really only becomes clear once a suit is launched, and then you go through the discovery period and those kinds of issues. And when a court is looking at, and when we're providing defense to a physician for a lawsuit, there are two bases for that defense. One is standard of care, and one is causation. And let me just describe those a little bit for you.
Sure.
So the courts have said and made it clear that perfection is not required in medicine.
Okay.
It's what is reasonable care given the context of the scenario. So that is really important. That's important when we get experts on the file. It's important in your defense. So you'd be judged for the care you delivered based on a standard of care, based on the perspectives of your peers and the opinion of your peers, i.e. an expert, what the guidelines say and what the standard was at that moment. And as we all know as physicians, things do happen in medicine. Healthcare is a risky business. People do get sick and bad things do happen. The question in that is, was it negligent care or not? And bad things can still happen when the care has been excellent. It's proving whether the standard of care was breached is the behind the tort and the defense of the tort. Causation is a second leg to that stool. Bad analogy. The causation defense is, but for my actions as a physician, this outcome would not have happened. And they are distinct, right? So you can imagine a scenario whereby the standard of care was breached and my actions led to the negative outcome, right? That type of case is largely indefensible depending on the scenario. But you can also imagine whereby your actions did not impact the outcome,
right?
Even when the standard of care might not have been perfect. So the person was going to have the outcome that they had. So that's the second part of a defense related to a claim.
Thank you for elaborating on that. That does help quite a bit. So, I'll just share a quick personal story. So yesterday I came home, I opened up my mailbox and I saw these 2 thick packages. I opened them up and it said court appearance. I freaked out and then I went down and it said Alibaba, the company, is being sued and you as a shareholder are being notified. I was just like, my heart skipped a beat just in that scenario. So I can only imagine what happens when somebody is served with a statement of claim. This has to be a very stressful situation. But let's say one gets that statement of claim. What's the next thing that they should do? Like, is it just contact the CMPA? Like, what do they do next?
Yeah. Thank you. So after you've sat down and read through the statement of claim and had the reaction that you've described, we absolutely ask members to call us. And you're going to want to call us anyway. As recall that I said when members call, they typically largely feel more informed and they feel better about knowing what is expected and what the statistics say about a case, knowing the timelines and knowing the process. And that's one of the most important things that we can provide. So when you get a statement of claim, when you're served, we encourage you to call us right away. And you'll have a conversation with the physician advisor. Your file will be opened, and you will be asked to describe the scenario and provide some of the details related to the case. All civil legal matters, all lawsuits, you'll be assigned a lawyer in your province, and that lawyer will become your main point of contact in the case. You still have a physician advisor at the association who manages your case and whom you can call at any time for support. When you call in, we have a secure portal. You'll be asked to actually send in your statement of claim. And we typically ask you to begin writing down your narrative around the case because memories fade and the time frame is long. So typically lawsuits average about 4.5 years from start to resolution, and some can be quite a lot longer, such as obstetrical cases or complex neurological cases. They can be upwards of 8 years. So it's important to write that narrative for your own record and mark it confidential and privileged, and that allows you to have the memory of of what you did at that time. And once we've started that process and you've assigned your lawyer will walk you through all of the processes and what you need to do. And the final bit of advice we give physicians during this period is we do say that it is a marathon, not a sprint. And the skill of compartmentalization that all physicians have is really important in this, being able to put aside the suit and focus on your family, your friends, and those things that bring you joy in your practice. And your lawyer and your physician advisor is there to carry the weight of the lawsuit.
That's a really helpful overview, Todd. I did want to ask, you mentioned the physician advisor, our first point of contact. Then we'll be put in touch with a lawyer. And you mentioned that this process can take years in many cases. Along the way, I'm sure there are a lot of ups and downs. It's probably a bit of a roller coaster, but did the CMPA offer additional services like support, counseling through this whole process as well?
Yeah, that's a great question. So your first 2 points of contact for support are your physician advisor and your lawyer. Yep. And our lawyers across the country are medical legal experts. They've been doing this work for decades, and they are a sound point of support for the physicians on an ongoing basis. And our lawyers typically go above and beyond for that support. It's not just medical legal support and advice. And so we're quite proud of that. And part of our ongoing internal education is really around what physicians need to support them during this time. We do have a physician health and well-being area within the department. We do offer coaching and support related to that. And we are linked to a variety of external resources that we can suggest to you, including physician health programs in every province and other personal support that we have connections with.
Can I ask a few questions about the lawyers, if I may? The lawyers, are they employed by the CMPA or are they external to the organization?
They're external to the organization. So we have lawyers across the country with firms that we've used for decades. So we have retainers with all of those firms across the country. So they become experts in this work, in this medical legal work. And the other thing that is unique to Canada really is the way that our law firms share their knowledge and support between firms in order to be able to provide the best defense for physicians.
And you mentioned that the lawyers who will be assisting us, they are specialists in medical legal work. Is that right?
That's correct.
And, in a world now where it's very easy to access information, we all tend to do research on everything. Is it possible for us to choose the lawyer we want, or are we typically assigned a lawyer? How does that work?
You're typically assigned a lawyer, and depending on the allegations in the case, we determine which. All firms are generalists, so all firms are appropriate, but some firms will have specific lawyers who are specific in certain areas that we may assign you to. But we do assign the lawyer based on our knowledge of the support that you need.
And this process has to involve a lot of time, legal fees along the way. In terms of covering the legal fees, who's responsible for that?
So the CMPA is responsible for all of your fees. So once your eligibility for assistance is determined, then the CMPA and the mutual picks up your legal fees as part of the process.
Now, some people may wonder, okay, typically the advice is to contact the CMPA, but do people have alternatives too? Do people use alternatives? Perhaps you could maybe touch on this a bit.
Sure. So one of the other things that makes the CMPA unique is our occurrence-based protection. So what does that mean? Versus an insurer, which provides claims-made protection. So your car insurance, your house insurance. Let me just describe the difference because it's really important. And I'll get to answering your question. So occurrence-based protection means that as long as you were a member of the association at the time the allegations were made, 20, 30 years ago, you're long retired, the CMPA is still there for you, right? So we are still there. And so if an allegation comes up based on the care you delivered in 1985, and you were a member in 1985, you're generally eligible for assistance for that allegation.
Okay.
Versus an insurance company, which, and you hear this in the States a lot with medical malpractice insurance, which requires you to have tail coverage. So if you were to retire with a typical insurer, you need to retain a policy to provide you protection for that tail because they're not occurrence-based protection. So what that means is financially is that our organization is set up in order to retain resources and funds in order to provide that protection for at least 40 years since your care. So that's exactly why our funding model is as it is and how it differentiates us.
So let's say a case happened, let's say 5 years ago, when a physician was working. At that time, they were a CMPA member paying their dues. since then they have retired, they're currently not paying any CMPA dues. They're still eligible for protection.
They are absolutely eligible for protection.
Okay, got it.
That's correct. And physicians do have alternatives, right? So there are insurers out there that will provide medical malpractice protection. They are typically insurers on this claims made approach, which means that if you were to cancel your policy with that insurer, in your scenario, you would not be protected in those kinds of scenarios.
That's very helpful. So we talked about a lot about the statement of claim, contacting the CMPA, the physician advisors, the lawyers. Now we're going to get to the pre-trial stage. And I imagine there's a lot of things happening here, a lot of back and forth, information gathering. Can you just talk us through like what to expect at this stage? I imagine there's going to be a lengthy discovery process. Maybe start there or however you see fit, but I'd love to know more about the key elements of the pre-trial process.
Sure. So you've named it correctly, the discovery process. It's also in the States called the deposition, you may hear.
Mm-hmm. Mm-hmm.
Physicians tell us this is one of the most stressful times in the course of the lawsuit. And the reason is it's the fact-finding process. And so it really is a series of interviews where the facts are drawn out such that there are no surprises to either side, the plaintiffs or the defense, such that the plaintiffs can make their case and the defense can make their case based on the facts. There should be no aha moments in the courtroom. These things should come out during the time of discovery. The discovery is typically held for the defendant, the physician, and then it's held for the plaintiff. Typically, the plaintiff is not present in the discovery process.
Okay.
And then the physician is not involved in the plaintiff's discovery, typically either. And as I said, the purpose is really to fact find and to build the case and prepare for a settlement or trial.
And I'm assuming that along the way in this discovery process, there will potentially be expert witnesses involved, maybe on each side. And I was hoping, Todd, that you could speak to expert witnesses, what their role is. My superficial understanding is that they are experts in the subject matter, but they offer an unbiased opinion, not to really benefit one side or another. But I'd love for you to elaborate on what their role is. How are they selected?
Yeah, absolutely. So you're absolutely right. So the role of the expert is to assist the court. The expert is not the advocate for the plaintiff or the defense. And they are there to speak about the standard of care, like I talked about, or you can have experts who speak about the causation, or you can have experts who speak about the damages. So they're typically accountants or folks that are involved in more typically insurance industry, where they're looking at being able to price the damages. And so those are the different types of experts that are brought to the table. The other thing just before I go there, if I may, just one last comment about the experts. It's really important to find experts related to the standard of care that are contextually appropriate.
Yep.
So what I mean by that is, and as I said, the courts do not expect perfection. So the standard of care expert that you want really is dependent upon where you're practicing. So if you're in a small rural emergency room and you have a case, you want an expert who has practiced in a small rural emergency room and knows the standard of care and the realities of practicing in that environment. And you're not being held to the care that might have been delivered in a quaternary care center, which would be very different. So it's just important to pick the experts and have the experts that are relevant to the context in which you were practicing.
Can I ask one clarifying question on the experts? Like, let's say an expert is selected on the plaintiff side. Is it possible for the defendant side, the physician side, to say, we don't really agree with the expert selection because they perhaps, don't work in the same setting or have the necessary experience? Is it possible to object it?
So you wouldn't typically object it, but you would defend against it. So typically that's part of your defense would be built around the fact that those opinions are based on a different environment.
Got it.
Yeah.
I'm assuming that in some provinces there may be a mandatory mediation process. Maybe in others there's not. But can you tell us about this process and what it entails?
So on the issue of mediation, so the definition of a mediation is really an attempt to settle. And there are two different kind of broad categories of kind of this pretrial period and trying to get to a settlement. So you've gone through the discovery, you've built your case, you are aware of the weaknesses of your case, and now you go into some sort of discussion that looks to either determine you're going to trial or determine that you are going to settle or determine that the case actually should be dismissed. So the two ways are really a pretrial process, which is in front of a judge. So a pretrial hearing is in front of a judge who takes sides based on the fact. So it's almost like a small mini trial, in the sense that the judge will be saying to either side, I think you have a good case, or I don't think you have a good case. I suggest you look to settle. I don't support this going to trial because you'll lose. That kind of discussion. A mediation is a little different. So mediation is typically could be a retired lawyer, but it's not a judge type format. And the mediator's role is to find a middle ground. So it's a compromise. It's a compromise. So the goal there is to find a way through that is a settlement or a dismissal that's leaves everyone whole and is agreeable by both parties.
Todd, I'm curious. You've mentioned a few numbers along the way in terms of how many cases come up for review, but from start to finish, like what percentage of cases would you say end up making it to trial? So now I guess let's get to the trial stage. What percentage of cases have to go to trial?
Sure. So I'll back up that and provide a few other data sources. So when we look at all civil matters and we think about, and this is the good news, we think about what is a favorable outcome, all comers related to civil matters, about 60% of all those cases have a favorable outcome. Either they're dismissed outright, so they never go ahead, or there's a win at trial. 40% of those cases have a adverse outcome. Either there's a loss at trial or we settle the case because there's no defense to the case. Okay, so 60-40 split. Only 5% of all of the cases go to trial. So very few cases go to trial. When they do go to trial, the physician usually wins about 75% of the time. So the reason that number is so high is because of the workup that the association does and the support we provide with respect to the experts. And if we don't believe that the case is defensible, we will explore settlement. And that's really important. Last year, our compensation to patients was $308 million in 2023. So that's a very large number. Over the last 10 years, we've compensated patients $2.4 billion. Now recall, because of the way the association is structured, part of that payment are typically for cases 4 years old, 10 years old, 30 years old, right? So they go back quite a long time, and they've just reached a conclusion at this point. So the reason that the physician's typically successful at trial 75% of the time is because we do, when there is no support, we look to settle the case. Now the number of civil lawsuits, the total number is around, as I said, about 850 across the country every year. That number is not going up. And the number is not going up because the plaintiffs' counsel are being quite selective in the cases that they're bringing forward. But by doing so, they're bringing forward cases that they firmly believe that they can win. So you may see a change in those numbers going forward. But for the time being, those are the statistics that we...
Todd, I really appreciate those statistics just to help people understand what the landscape looks like. Now, just if I may ask, behind the scenes, there has to be a lot happening at the CMPA. Like Is there once these cases come up, these lawsuits come up, like I'm assuming, is there some sort of committee at the CMPA that is actively reviewing everything? Like, are you able to shed light on that? If I'm asking too much, just tell me to zip it. We can carry on. But I wanted to just understand what was happening behind the scenes.
Yeah. So the cases are reviewed as a partnership between our general counsel and the physician advisor and the management team at the CMPA, the provincial council, and the member. So all are involved in the discussion around the defensibility of the case and the direction of the case. The decisions around settlement or go to trial are a partnership between all involved. The member does have the ability to ask for a consideration of the decision of the association, which goes to a panel of their peers at the association, which is comprised of members of our board, our council.
I just wanted to get a sense of when these cases go to trial, are they in small courts, regular courts? Is there a jury present? Is there not a jury present? Does this depend on what the kind of proposed settlement is? Like, I'm just curious, in a nutshell, what are the main considerations here?
There are small claims courts for medical liability cases, so a good number of those, especially in Quebec, they use small claims courts more commonly than other provinces do. And some provinces are increasing the value of cases that can go to small claims courts in order to enhance the access to justice of patients who don't feel they're able to move a case forward with a lawyer. But typically, the normal court system is utilized, and the different layers of courts with respect to appeal are part of the tort-based system. Most cases are based on a judge alone type of trial, and certainly more rarely, certainly less than 20% of cases are by jury. And some provinces are much less likely or do not use juries at all. And it seems to be the trend. Certainly during COVID, we couldn't have juries, so they were all by judge at that time. And the courts, in order to enhance efficiencies, are really more likely to be using a judge-based system.
Let's wrap up by talking about the settlement, any monetary damages. So you mentioned some statistics, like in the last year, the CMPA paid plaintiffs' patients, or in 2023, $308 million. Like, that's a large sum of money. And of that, is there anything that the physician would be expected to pay out of pocket? I just wanted to clarify that.
Our role is to protect the integrity of physicians and to compensate patients who are proven harmed by negligent care. And so that is our mandate. And so we pay those damages on behalf of the member, and the mutual pays those damages on behalf of the member. That's the value of the mutual. There are only a small number of what we call heads of damages that the CMPA wouldn't pay, and not to get too far into the details, but there's something called punitive damages, where the courts can, in addition to the normal damages, can assign, which is really a penalty to the physician, and that's something that the physician pays themselves. But they're not responsible for the costs related to the court, and the CMPA provides the full cost of damages.
Is there anything else in this process from start to finish that the CMPA would not cover? Like, let's say a verdict is made and the physician decides to appeal the case. What would happen in that setting? Would that also be covered by the CMPA?
So the decision to appeal is made by the association in consultation with the member and the expert. And we don't typically appeal cases unless there are sound reasons to appeal the case, but we do appeal. It's not to say we don't appeal. So if the association decides not to appeal a case and the physician wants to appeal a case, they would do that on their own accord, which obviously has financial implications for the physician.
Let's say a physician goes through this experience of a lawsuit and then resumes practice afterwards. What can the physician, let's say they're still a member of the CMPA, what could they expect in terms of their dues to the CMPA? Would we expect that to change at all?
They do not change. Your dues do not change based on your utilization of the CMPA. So we often hear from members that they didn't want to call because they didn't want their costs to go
really?
up,
Okay.
even for advice sometimes. And that is not the case. We're a mutual defense organization, and this is one of the other elements that makes us unique. So we do not individually risk rate. We cannot individually risk rate physicians. So on your car insurance, if you put through a number of claims, your rates go up. They do not as part of a mutual. So no, we do work with you though, with respect to providing support and advice. And this is where the other unique element of what CMPA offers is we take all of this knowledge. We actually have the largest medical legal database in the world. And we were able to mine that data and the knowledge with our research department and translate that into learning and education for members. So that's one of the other elements of our stool is to be able to translate that information back into the profession and back into the system in order to make care safer.
That is really great to hear, Todd. Last question on the core topic is residents, trainees. Are they ever implicated of malpractice, or does it usually always fall on the staff? Just curious about this.
No, they absolutely are named. And as you probably know, anytime a lawsuit is launched, typically the net is wide with respect to anyone who's had contact with the patient. And in fact, the plaintiffs will often reserve the right to add people in, and they call them Jane Does or John Does as part of the. So if you see a Jane Doe or John Doe in your statement of claim, it's because they have not yet identified potential people in that statement.
Interesting.
Of claim. Part of that may be the resident. Now, typically, that's the value of residents being members of the association in that we're providing support to the resident. Obviously, a very traumatic time earlier in their career, and we offer defense that provides the full picture of the case, right? So now residents are sometimes, they are named and they're sometimes found negligent in the care that they provided. We then have to look at the apportionment if there is a settlement, the apportionment of the settlement between how much was related to the role of the resident versus how much was related to the role of the staff person.
This all made me think of one last question. Like when you get that statement of claim, there's a lot of information on there. I'm assuming there's also a monetary amount, an amount that the plaintiff is attempting to sue for. Can you just give us an idea of, I'm assuming that can be anything, but what ranges can we expect to see on that statement of claim? Just so people can go into this with a bit more knowledge.
It's an important question and a hard question to answer, because the range can be very, very wide. And typically the opening foray of the plaintiff's estimate will be high. And I'd mentioned the term heads of damages. Those damages just aren't one number. They are comprised of a variety of different elements based on our court system and what each province allows for different pieces of those heads of damages. And one of the biggest parts of the damages is often related to ongoing care of the patient. So when we look at cases that are expensive, they're typically high value cases based on a young patient requiring ongoing care for the rest of their life. And that increases the amount of damages. So there's many different elements to how damages are comprised, and the range is very high. We've seen cases certainly in the $14 to $15 million mark over the last number of years.
Okay. Thanks for that. And Todd, any closing thoughts that you wanted to offer, whether it's related to malpractice, safe care, the CMPA, anything at all?
Thanks, Yatin. I really think the message for members is to call us. I think that, as I mentioned before, some physicians think that, by calling the CMPA, you're admitting to some sort of breach or liability. That's not the case at all. We're there as your support system in practice at a time that's probably never been more difficult. And so please call us, and we will help walk you through whether it's a civil lawsuit, whether it's a college complaint, whether it's a hospital complaint or a hospital matter, or just a preventative type of discussion related to a variety of different issues that you'll face in your practice. We're there to help reduce your stress related to that and reduce your risk. So we're there as your partner.
Todd, this was very eye-opening. I learned a lot, and I just want to say thank you again for being so gracious with your time. I really appreciate it.
Very welcome. My pleasure.
Now, just as an aside, because some people may be wondering, I did ask Dr. Watkins offline, what if somebody wanted to navigate this situation outside of the CMPA using their own legal team? Of course, we are allowed to do this. Now, there are a few considerations. One is we would be responsible for our own legal fees. And if there was a lawsuit and we lost that lawsuit, then we would be on the hook for any damages owed. Thank you, as always, for listening. I know today's topic is one that we don't necessarily want to be thinking about too much, but it's certainly one that we do need to have an understanding of. So if you found it useful, I'd be grateful if you can share this with people in your network. And we'll see you in a few weeks' time. Stay well, stay savvy.